Next, we have Senator Leno. Members, this is item SBX2, number 5. Please proceed.
Thank you, Mr. Chair. I promise I will not get on my soapbox. I'll just stick to the fiscal with regard to this bill.
Promises, promises.
I will keep my promise. So just to start with a quote from the California Department of Public Health, which recommends that, in their words, existing laws that currently protect minors and the general public from traditional tobacco products should be extended to cover e-cigarettes, and that's what our bill will do. To bring it under the Smoke-Free Act as well as the STAKE Act, the Stop Tobacco Access to Kids Enforcement Act. And by doing so, keeps everything under the same infrastructure, statutory infrastructure, which will save the state and businesses money. For example, the STAKE Act savings, the Department of Public Health's division overseeing these operations can draw from existing federal funding to implement these programs. With regard to smoke-free laws, businesses would not have to create additional signs. They could use their same no smoking signs once we regulate e-cigarettes as tobacco products, and that vaping would be the same under law as smoking for purposes of enforcement. And then also the licensing laws, which require e-cigarette retailers to be licensed under the existing Cigarette and Tobacco Product Licensing Act. And Senator Bell, of course, has the bill that will raise that $100 to $265, and this would fall under it. So for all those reasons, this, we believe, is the fiscally sound way to proceed with regard to the regulation of these cigarettes, and I would ask for your support.
Thank you. Witnesses in support.
Good morning, Mr. Chair and members. Sawait Seam on behalf of Health Access. We are here in support. We want to note that comprehensive tobacco control legislation and strategies in California have saved more than 1 million lives and more than $1.34 billion in the last 25 years. However, the use of tobacco products currently costs Medi-Cal $3.5 billion in direct expenses. This new pathway to tobacco addiction via the use of e-cigarettes really threatens to undermine the great progress that we have made as a state in tackling tobacco use. The explosion in the popularity of e-cigarettes among children really should be a flashing red light for us as we face this serious problem. For these reasons, we respectfully request your support. Thank you.
Tim Gibbs, American Society Cancer Action Network, and just be real brief, but the CDC has shown that nationally the usage of e-cigarettes among high school students has tripled in 1 year, gone from 600,000 students in 2013 to over 2 million in 2014. That level of nicotine addiction in California is frightening in the sense that, you know, those teenagers who are experimenting with nicotine now are likely to be nicotine addicts and likely to put a huge burden on our healthcare system. So not only will this bill ensure that that youth avoid a lifetime addiction, but that it does so in the most economical way by treating them as a tobacco product. And given that the tobacco companies have embraced e-cigarettes and control a bigger share of the market, it's critical that we treat them like what they are, which is tobacco products.
John Lovell on behalf of the California Police Chiefs Association, the California College and University Police Chiefs Association, and the California Narcotic Officers Association. Bringing these products under the rubric of the STAKE Act not only has positive policy dimensions, but it has an extraordinary fiscal benefit as well.
Additional witnesses in support.
Nicole Wertelman on behalf of the Alameda County Board of Supervisors in support.
Thank you, John.
Tim Madden, representing the California chapter of the American College of Emergency Physicians and the California chapter of the American College of Cardiology in support.
Tim Schott on behalf of the San Francisco Bay Area Rapid Transit District. The BART board has not taken an official position on this bill, but the board did support the good senator's SB 140, and BART has passed a prohibition for e-cigarette use in transit facilities.
Thank you, Mr. Chair. Members, Megan Allred on behalf of the California Dental Association, also in support.
Deputy Attorney General on behalf of Attorney General Kamala Harris in support of the bill.
Gregory Kramer on behalf of Planned Parenthood Affiliates of California in support.
Dr. Donald Lyman, California Academy of Preventive Medicine in support.
Alicia Sanchez, representing the California Medical Association in support.
Lindsay Freitas with the American Lung Association in California, proud co-sponsor in strong support.
Kat DeBerg with the Health Officers Association of California in support.
Karen Liggett and trying to protect children, so thank you, Senator Leno, for the bill.
Callie Hampton on behalf of the American Heart and American Stroke Association, proud co-sponsor of this bill. Sylvia Solis-Shaw on behalf of Los Angeles City Attorney Mike Feuer and on behalf of the Board of Supervisors of Solano County. Thank you.
Thank you. Additional witnesses in support. Witnesses in opposition. Finance.
No file.
Comments or questions from committee? Seeing and hearing none. Senator Leno, you are taking the amendments, correct?
That is correct.
Great, thank you. Members, this motion is a due pass as amended to the Senate floor. Secretary, please call the roll.
Laura?
Aye.
Laura, aye. Bates? Bates, no. Bell? Bell, aye. Hill? Hill, aye. Leyva? Mendoza? Nielsen? Nielsen, no.
3-2, we're going to hold this item open to allow absent members to add on.
Thank you, Mr. Chair. I hope I kept my promise.
Thank you. You did very well. Hopefully, second time's a charm.
Mr. Chairman, are those amendments available? I'd like to look at them if they're available.
Yeah, we have those amendments. Thank you. Senator Cooley, sorry, apologize for the wait.
No problem at all.
Oh, yeah, to make an announcement, we're going back to regular committee session. Members, this is AB 12 by Senator Cooley. Mr. Cooley, the floor is yours.
Very good. And I know this bill is headed to suspense. I just wanted the opportunity to address the committee with respect to it. Excellent analysis by Mr. McKenzie of your staff. As he notes, this bill is very similar to SB 366 of 2011. That bill actually grew out of the Democratic Caucus policy retreat that year, proposing a top-to-bottom review of regulations. What is different in this bill is it proposes not that it be done on a crash basis, but that this be undertaken during the course of the remaining time our governor sits in his office. The analysis also points out that the last time there was a top-to-bottom review of California regulations for duplicative, conflicting, overlapping regulations was in 1980, when Jerry Brown, as governor at that time, tackled burdensome regulation by the introduction of the OAL process. We have seen our voters support good government in California, the passage of Proposition 30. Those dollars will eventually go away. A vital part of backfilling those dollars is growing our private sector economy. And I think that the top-to-bottom review of regulations that this bill would initiate, not on a crash basis, but over a 2-year span of time, will be national news in the New York Times, the Wall Street Journal, if California undertakes this sort of thing. I think it will be the talk of every executive suite and every Fortune 500 company in the country, and signaling that California is a place for them to come back and bring business. So I see this bill as sort of fitting into the challenges we face of governance in the years ahead. And as I say, I acknowledge the indebtedness that I have to the State Senate for the ideas present in SB 12. It specifically contemplates also as a part of this review that as agencies identify duplicative or conflicting regulations, that they will notify the standing committees of the legislature. So it's also a way to strengthen our committee process as we are a co-equal branch of government. The bill has no opposition. Here to testify in support is Michael Shaw for the California Manufacturers Technology Association. I'll turn the mic over to him.
Thank you. Witnesses in support.
Thank you, Mr. Chairman, members of the committee. Michael Shaw with the California Manufacturers and Technology Association. Without going into the long speech of why this is a good reason, I think it makes sense for California to take a look back at the regulations that it has put in place over the last few decades to assess what is necessary, where there are opportunities for improved efficiency, both from the government side in terms of potential cost savings to the state in the long term, but also in the interest of economic development and creating a more hospitable environment for businesses, particularly manufacturers in our case, to grow and prosper. That has significant financial benefits to the state as well in terms of additional tax revenue ultimately, and Californians being employed, which reduces costs on the social benefit side of the equation as well. So we appreciate your support coming off of suspense.
Thank you. Additional witnesses in support.
Valerie Nera for the California Chamber of Commerce in support on policy.
Additional witnesses in support.
Thank you, Mr. Chairman. Senators, Julianne Broyles here on behalf of the Family Business Association of California, the California Association of Joint Powers Authorities, and Associated Builders and Contractors of California, all in strong support.
Dane Hutchings with the California Grocers Association in support. Jason Schmelzer on behalf of the Pacific Merchant Shipping Association in support.
Witnesses in opposition, please come forward. Seeing none, Finance.
Department of Finance remains opposed to this bill due to its significant upfront state costs that were not envisioned as part of the administration's current fiscal plan. The Office of Administrative Law alone estimates their 2-year cost from the bill would be about $1.4 million. And because of the magnitude of the review process and the likelihood that most state agencies would need to hire additional attorneys, statewide costs are estimated to be in the tens of millions.
Thank you. Thank you. Comments or questions from committee? Senator Nielsen.
Folks, the cost of regulations out of control in the state of California, very particularly including underground regulations that do not have any statutory basis or foundation, are in the billions of dollars. So to finance and to the governor, I'll argue this is a very small expense to incur. Assemblyman, can I ask you, and I would like to work with you while it's on suspense, to have maybe some inclusions in here. You talk about duplicative, overlapping, inconsistent, out-of-date regulations, and I would want to see added to that the point I made, underground regulations, meaning a regulation that's proffered but one that does not have a statutory foundation. We are full of underground regulations that are dictating policy in California. In addition, I'd like to discuss with you, in the future, we not exempt agencies of government, as was done last year to the Water Resources Control Board, exempting them from OALL review. I was around for the creation of the Office of Administrative Law, working with then Speaker Leo McCarthy. And our point was that we've got to make sure that a regulation has a statutory basis, is not an underground regulation. Interestingly enough, it also required that the OAL examine the fiscal consequences of that regulation. Now, that's been ignored forever. I believe it's still in the regulation and in the statute, though. But I'd like to talk with you about these points, that we would not allow the exemption from the OAL review, that we would ensure, as in this inquiry of the agencies, that they have to cite their authority. Of interest and of humor, I read a legal case a few years ago. I don't know why I read this case, but I did. It was kind of picked up at random. It was a Caltrans action. And in the demurrer, the judge had asked Caltrans to cite their authority. Their citation of authority was, "We are Caltrans." I'm not kidding. And I wasn't even surprised. So please, let's have a conversation about that we might be adding something to the bill. I'm not sure I want to read the bill, but I'll ask for a meeting with you, Assemblyman Cooley. Thank you for a good idea.
Thank you, Senator Nielsen. Any additional comments or questions from committee? Seeing and hearing none, Senator Cooley, would you like to close?
Yeah, today I don't contemplate any further amendments. I think the bill will greatly strengthen our status, the Senate and the Assembly, as co-equal branch of government. Information will come out of this process which will help all of our standing committees understand the regulatory programs in their midst. I think the outstanding thing here, I actually worked in the building during the era of Leo McCarthy when the law was passed. I know that the conversation was thicket government. Government had become such a dense thicket, it was hard to move through it, hard to move anything through it. The governor signed that bill, OAL, Governor Brown signed that law in that era to deal with thicket government. And I think as we look to grow the sort of economy, to improve to reduce our poverty levels here in California, have well-paying jobs, to offset the eventual loss of tax revenues, I understand there is expense associated with this, but I do believe that this is a measure that the Senate identified in 2011 in their policy retreat. I think it will be national news. It will set the standard that California is systematically looking how to grow a better future for all Californians. I very much thank you for the opportunity to be here today. I request and I vote. Thank you, Mr. Chair.
Thank you, Mr. Cooley. Without objection, we'll move this item to the suspense file. Next, according to our agenda, we have Assemblywoman Chang. Ms. Chang has AB 435 members. Ms. Chang, the floor is yours.
Thank you, Mr. Chair and committee members, for the opportunity to present to you AB 435. I understand that this item has been flagged with extremely high costs and therefore will be going on suspense, so I am here today to focus on the fiscal components of the bill. Briefly, AB 435 is a measure to increase transparency and accountability for two of California's most influential agencies, and it achieves this by requiring Cal EPA and the Natural Resources Agency, as well as the boards and commissions under them, to webcast all public meetings, make them available online for future viewing, and provides a mean through which members of the public may participate remotely for public comment or question periods. With the technology available today, this legislation can easily be implemented by the agencies at minimal costs. Just a little over a week ago, my staff demonstrated this by live streaming a meeting of the California Energy Commission with the use of nothing more than their personal cell phone, a free app, and an internet connection. My staff met the standard proposed in this bill with, again, merely a personal cell, a free app, and an internet connection. Cost practically nothing or minor and absorbable. We have worked with all policy committees and multiple stakeholders to make sure that this legislation is as simple to implement as possible. Previous amendments have included removing the requirement to webcast workshops, specifying that the webcasts were to be archived digitally as opposed to physically, and accepting meetings that take place at off-site locations and ensuring that the affected agencies would not be in violation if there was an unpreventable technical error. Despite these amendments, the estimated cost of this legislation has somehow increased since the time it was heard in the Assembly Appropriations Committee. It is my sincere belief that the projected costs have been exaggerated, as it is the case that these requirements are not only simple enough through the use of modern technology, but also that multiple boards and commissions under the two agencies are already webcasting their meetings today. Nowhere in this bill does it require that the webcast be made into a Hollywood-style production. It simply seeks to make government more available and more transparent to millions of impacted Californians who do not live close enough or do not have the free time to drive to Sacramento every time a regulation affecting them or their business is discussed. The diverse group of support this bill has received is a testament to its significance, from unions to business to environmentalists. I hope that the benefits of this bill will be taken into consideration at the upcoming suspense hearing, as well as how inexpensive and widely available webcasting technology is today. And as a technical clarification, the comments in the analysis state that the projections did include the cost of webcasting workshops, which we have specifically amended out of this bill. Thank you.
Thank you. Witnesses in support.
Mr. Chair and members, I'm Trudy Schaefer, representing the League of Women Voters of California. Democratic government depends upon the active and informed participation of citizens in government. And Californians, we believe, should have the opportunity and the right to participate actively in public meetings, no matter how remote they are from the location where the meetings are taking place. This bill would follow the practice of other agencies that are able already to provide webcasts and the technology to participate remotely. I, too, was surprised when I read the fiscal estimate after following the Assembly Appropriations estimate and knowing that the bill has been narrowed even slightly from that time. So I do urge your committee to pass the bill when it comes and bring it off suspense. Thank you.
Thank you, Mr. Chairman, members of the committee. Michael Shaw, California Manufacturers and Technology Association. This is an important bill in making a greater opportunity for Californians to participate in the regulatory process. We believe that that helps provide greater insight for the regulatory boards, making decisions that affect Californians both in business and as well as in their personal lives, and that the potential savings from that through increased participation, better input, will be a benefit to the state in the end.
Ingrid Broston with the Center on Race, Poverty, and the Environment. This bill originated from residents that came together last year that are impacted by toxics, and they were recognizing impediments to good decision-making and protectiveness from agencies. And they determined one impediment was the simple inaccessibility of agency decisions to those that are most impacted by environmental pollution, and that is low-income communities and communities of color. It is these very communities that are most impacted by some of these agencies' decisions, yet have the least resources available to them to travel to Sacramento to participate in the meetings. So when you consider this bill, I ask you to compare the minor costs to agencies, many of which already have the technology necessary available to them, to the incredibly high cost of traveling for these residents that are highly impacted, taking work off, figuring out ways to transport themselves up here, maybe spending the night. So when you look at that, this actually increases the efficiency of agency decision-making. It improves public awareness of issues. It improves agencies' ability to understand what's happening on the ground in the communities, and ultimately we'll have better agency decisions from this. Thank you.
Thank you. Additional witnesses in support.
Valerie Nara for the California Chamber of Commerce in support.
Cindy Hillary on behalf of the 34 rural counties in California in support.
Witnesses in opposition. Finance.
I don't have a file on this bill at this time. We share the author's concerns about some of the estimates we were given from agency and are continuing to look into it.
Thank you. Comments or questions from committee? Senator Bates.
I'd like to commend Assemblymember Chang for this legislation. They certainly, the agencies that are involved have a significant impact on our California businesses, and they certainly are going to benefit from this kind of accessibility. I think we're all, concerned about the cost, and I'd like to ask our chairman, Senator Lara, if we do a little digger deep on this, because I think the accountability that the public is asking for really enhances democracy, and this is an opportunity for people to really be more participatory in their government at every level, because many don't understand that the commissions and committees that give us recommendations, very, very important and very impactful, and we hope that's a positive impact and they have an opportunity to really engage. So thank you for bringing it forward, and we will work really hard on taking a look at the costs, because it seems pretty high. Yeah, agree.
Great, thank you. Ms. Chan, would you like to close?
Yes, like I've mentioned, my staff was able to do it for no cost, essentially, with just a cell phone and a free app and just an internet connection. And I also wanted to highlight that the Privacy and Consumer Protection Committee, our very first hearing, we used Reddit to be able to engage the public, and that was also at zero cost. And I do implore that the committee look into the proposed costs and to see if those are in fact real. And with that, I ask for your support when the time comes. Thank you so much.
Thank you. Without objection, we'll move this item to a suspense file. Next, we have Assemblymember Alejo. Mr. Alejo, my understanding is you're waiving presentation on AB 1390, correct? You have two items that are suspense candidates, AB 443 and AB 684. Let's begin with AB 443.
Okay. And at the end, Mr. Chairman, I'm presenting a bill for Assemblymember Cooper, AB 1042, just for
correct
procedure-wise. AB 443. Thank you, Mr. Chairman. Today, I'm here to present AB 443, a bill that is sponsored by Attorney General Kamala Harris that focuses on temporarily freezing the illicit assets of transnational criminal organizations. Fiscally, the costs of this bill are likely going to be minor, and the bill will even result in revenue for the state because the provisions will allow for additional assets to be seized from these criminal entities. Gang violence and crime continue to be serious problems across California, and we must take steps to diminish the grip these gangs have on our most disadvantaged communities. By freezing the assets of criminal organizations, we hit them where it hurts the most, and we put a halt to their operations. This bill comes directly as a recommendation from an Attorney General report stating that there is a void in criminal law that essentially gives transnational criminal organizations notice prior to freezing their assets. This notice allows time for the organization to shuffle funds around out of state and beyond the prosecutor's reach, which effectively allows them to continue their operation. This bill is a step in the right direction to prevent this money shuffling and thwart organized crime in California. And before I conclude, Mr. Chairman, I'd like to point out that the safeguards that this bill puts in place in order to ensure that it only captures the serious offenders. First, in order for law enforcement agency to use the bill, they must first go to a judge and show that there's a substantial probability that the prosecuting agency will pursue criminal charges and prevail, and that the assets are tied to transnational criminal organizations. Further, they must show that the need to preserve these assets outweighs the hardship on the party effect and that will allow the assets being frozen. They will be destroyed, removed, or from the jurisdiction or otherwise unavailable. And finally, if an individual feels that their assets were frozen unjustly, they can petition the court for their return. The bill is narrowly targeted to the most serious types of criminal organizations and will help with the gang problem our state faces. I respectfully ask for an aye vote. I have some witnesses to speak in support.
Witnesses in support.
Yes, hi. Good morning, committee and chair. My name is Thomas Lawson on behalf of the Attorney General. We are happy to sponsor this bill, and we want to first, I think, thank Assembly Member Alejo and his staff for working with us throughout this process. The Assembly member walked through kind of what the bill does. I did want to just kind of point out a few things that the bill does not do. Specifically, AB 443 is not asset forfeiture. The bill merely allows prosecutors to preserve the status quo during an investigation. And I know there's been some examples brought up, and I want to talk about those a little bit. The bill does not change the standards or the process for permanent forfeiture. At the very most, in the scenario about grandma's house and things like that, a lien can be placed on the property to prevent it from being sold during that particular time. We will not actually go in, and law enforcement won't go in and take that house from the grandma. The goal is to preserve the status quo during that time. And so I just wanted to have that conversation. No one is going to be evicted or displaced because of this bill. And the Assembly member also pointed out, I think, a lot of the protections that already exist in current law for innocent folks. And then in this bill, we have amended it about 6 or 7 times by adding provisions to further protect folks so that they're not getting wrapped up in this bill unnecessarily. And so basically we want to give our local and state folks the opportunity to be on par with federal and to help them combat transnational criminal organizations, because they are the first line of defense for us in combating these crimes. So we would appreciate the committee's consideration on this matter. We look forward to your support as it comes off suspense.
John Lovell on behalf of the Association for Los Angeles Deputy Sheriffs, the Association of Deputy District Attorneys, California Association of Code Enforcement Officers, California College and University Police Chiefs Association, California Narcotic Officers Association, California Police Chiefs Association, Los Angeles Police Protective League, and the Riverside Sheriffs Association, all in support, and once again in alphabetical order.
Sean Hoffman with the California District Attorneys Association, also in support. I think we would concur with Assemblymember Alejo's assessment that to the extent that we can keep these resources from being disposed of prior to commencing the criminal action, we foresee a significant benefit to both the state general fund as well as local general funds. And with the safeguards that Mr. Lawson and Assemblymember Alejo walked through, I think the bill strikes an appropriate balance between giving law enforcement agencies an important tool to fight these transnational criminal organizations while also protecting property owners from any sort of potential abuse or unintended consequences. So we think this is an important bill and ask for your support when this comes off suspense.
Additional witnesses in support. Witnesses in opposition. Please come forward.
Good morning, Mr. Chair, members. Ryan Sherman, in support on behalf of the Long Beach Police Officers Association, Los Angeles County Professional Peace Officers, California Fraternal Order of Police, and Sacramento County Deputy Sheriff's Association, all in support, and we concur with the comments made by the previous speakers. Thank you.
So you're in support?
Yes, sir.
Perfect. Witnesses in opposition.
Yes, Mr. Chair, members, Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, Statewide Association of Criminal Defense Attorneys. We are opposed. On fiscal grounds, we have to keep in mind that this bill is much broader than it may appear, and that's why we're concerned that it will drive up the costs for court hearings. Number one, it gives authority to all 58 counties, meaning prosecutors in all 58 counties will be able to use this. It's not simply the Attorney General's office. Number two, it relies on the definition of a gang member or associate, which is quite broad. In current law, we've run into that problem in Los Angeles County. Conservative estimates are that law enforcement has identified 80,000 individuals who would meet this definition. On top of that, there's a broad category of offenses that would be covered. Our reading of it is that it would include vehicle theft, I don't want to say joyriding, but vehicle theft, which is a nonviolent crime. And we also think it's too broad and will lead to a lot of hearings because, number one, the safeguard that was mentioned, that you weigh the benefit versus the harm to the individual is not present at that particular hearing because notice is not given until after the assets are frozen or seized. As a result, we expect that there will be thousands of these hearings taking place because there's a secondary hearing that's requested after someone receives notice. And because of the broad definition, because of the broad offenses, we suspect that individuals will be caught up on this who do not fit the narrow scope of transnational crime. Two last things. This bill does not require that the underlying offense actually be a transnational criminal offense. It could just be a local offense that is part of the normal gang portfolio for prosecutors. And lastly, on Wednesday, the State Attorney General gang database, there is a request, JLAC, to audit that gang database because there's concerns that individuals are on there who should be removed and haven't been removed. So we think that for those reasons, we're likely to end up with thousands of hearings in California as a result of this bill. For those reasons, fiscal reasons we're opposed. We're also opposed on policy grounds.
Natasha Minsker, ACLU of California. We also are opposed on policy grounds and on fiscal grounds. This bill will allow law enforcement to secretly seize assets, private property, lawfully owned property from individuals, even in cases where law enforcement does not have enough evidence to charge that person with a crime. We believe that is on its face a violation of due process and will lead to lengthy litigation challenging the validity of the statute as well as individual challenges to unlawful seizures. For these reasons, we oppose.
Thank you. Any additional comments? Witnesses in opposition? Finance.
We don't have a position on this bill. We think that any cost to DOJ would be very minor, really de minimis, and that there is a potential for an unknown amount of revenue resulting from this bill. Judicial Council has indicated that they don't see any cost to the bill.
Thank you. Comments or questions from committee? Senator Nielsen, I was waiting for you.
Mr. Chairman, there's been kind of an assault lately on this asset seizure. This is a very good bill. Asset seizure has worked in California for decades, and it has had a crippling influence on criminals, criminal activity. A lot of it is property, you bet. People think, well, that's no big deal. Well, it's a big deal to the person's property who was taken, and at least it justifiably should be taken away, the criminals who took that property. This is a good bill. I urge an aye vote.
Thank you, Senator.
Thank you. Any additional comments or questions? I wanted to just ask a clarifying question. So under my understanding of this bill, is that the asset forfeiture will take place even before there's any charges filed. Is that correct?
Well, it just, the best analogy, Mr. Chairman, is similar to a search warrant. If you were to go give notice to the criminal organization, before you could arrest somebody that law enforcement is going after, before you could get evidence that is critical in the case, it would all be gone. And that's similar here. You go to a neutral trier of fact, a judge, who you present the case, and if you meet the legal burden of proof, then they'll give a warrant or an order to be able to seize those assets under those restrictions. The bill was further limited in both Assembly Public Safety and Senate Public Safety to address the most serious offenders, clearly defined definitions, and we even put a 3-year safeguard so that we could look back in a very short amount of time to see how this is working. With all the changes that we made on the bill, address those concerns so that this could be used effectively, used likely in only limited circumstances. But if we're serious about going after these people who are carrying out orders, giving orders, and resulting in deaths of young people like in Salinas, where we had the highest youth murder rate 3 out of the last 4 years, this is where you're able to hurt them the most is by seizing their assets. But, Mr. Chairman, we put a lot of safeguards to make sure that this is used appropriately and as an effective tool for law enforcement, only on seizing these assets. If you give them notice, those monies would be transferred away and you would be ineffective at hurting these organizations to continue to do what they do in our communities.
So how does this bill, and maybe we can have the ACLU come forward to, or have the AG's office, how does this bill interplay with Senator Mitchell's bill that we passed out of this committee?
Senator, the direct answer to your question is yes. This bill allows law enforcement to seize assets 60 days prior to filing any charges, which, since they may never file charges, may mean that they have unlawfully seized assets from individuals. In terms of Senator Mitchell's bill, we believe that they are inherently inconsistent in terms of the values they seek to promote. The current law allows law enforcement to file an order to freeze assets at the exact same time that they bring charges. So they actually can effectuate the goal of holding people's assets by simply doing that at the same time as they seek the charges, when they seek the grand jury indictment, or when they file the complaint. So current law actually allows them the protection to make sure those charges are not disposed of based on notice of when, those assets are not disposed of based on notice of when charges are filed.
Thank you.
So, yeah, really quick. So I think I want to focus on the thing that these criminal organizations value the most is money. And this allows locals to have the ability to be able to cut off that money, and so that the money does not disappear in form of assets, in form of assets or cash on hand. And so I'm not here to really talk about SB 443 Mitchell's bill, but in this scenario, again, we are not going in and taking people's assets. We're actually trying to just freeze the status quo. And what happens in that scenario is that prosecutors have to make and jump through a lot of hurdles in order for a judge to agree that this is even necessary. So we're not saying this is going to be done every day. We're not saying this is going to be done on a regular basis. This is specifically targeting transnational criminal organizations. So some of the most heinous folks involved in some of the most heinous crimes in California, and it gives law enforcement a tool to try and cut off the money so that the money is not transferred to another county, transferred out of state. And so it is a hearing that allows them to do that. There are, and again in the bill, several safeguards that allow for a prosecutor to make a case. And so it's not a generic thing where it's just, oh, we believe this is true.
Sure, we can get specifically delineate what those safeguards are.
Okay, yeah.
And just like to do that. We need to move on. So is there any other comments or questions from committee? Seeing and hearing none, Senator Alejo, would you like to close?
Yes, Mr. Chairman, just very briefly, just like a search warrant, you're able to go in and search even before charges have been done, arrests have been made, and you do it to go after individuals that are suspects or evidence that is critical in a criminal investigation. Same here, if you were given notice to criminal organizations, hello, we're coming in to get your assets, law enforcement would always be ineffective at getting those assets. They would immediately transfer them, hide them, and so they would do the obvious. What we're trying to do is a very limited tool with a lot of safeguards that meets due process of law, so that law enforcement throughout the state of California could have a tool that is needed to address some of the really serious gang issues that we have in communities, especially the most disadvantaged communities across the state, Mr. Chairman.
Senator Nielsen.
The test here would be probable cause, correct? Not beyond a doubt, but reasonable doubt. But just if there's probable cause that this property was illegally secured, that's your test in court, right?
Would actually be a substantial probability, which courts have interpreted as being higher than probable cause. Sorry, Sean Hoffman with the California District Attorneys Association. Substantial probability that we're going to file, and that when we file, we will be successful on the forfeiture.
Substantial prospect that you would succeed. That's another test, correct?
Yes.
Okay. That's a pretty high test, folks, and it's well established in law.
I just want, I'm kind of curious about that. Can you clarify on that?
Yeah, thank you, Mr. Chair. As was stated by the witness, the test is substantial probability that charges will be filed. However, that is during a hearing in which it's only the prosecutor that's present. The individual who is affected has not received notice yet. So you have one side essentially certifying that their office is likely to file charges sometime in the next 60 days. It's not a requirement that they file charges. And then the other safeguard that someone could request a hearing, that's later on. So they have to show that they may file and that they may win. But again, it's one-sided. It's essentially almost like an ex parte.
Thank you. Senator Alejo,
Mr. Chairman,
I'll allow you to
Just to add, it's on that quick point, because the standard, as your analysis points out, is that it's a substantial probability that the prosecuting agency will prevail on the issue of forfeiture, and that failure to enter the order will result in the property being destroyed, removed from the jurisdiction of the court, or otherwise made unavailable for the forfeiture. So there's both parts that have to be proven before a judge.
Okay. Thank you, Senator Alejo. Definitely a lot to discuss during the suspense process. Without objection, we will put this item in the suspense file.